Have you been stuck wondering whether to use a trademark or a copyright to protect something, or possibly whether you should use one of them instead of a patent? It's always best to start with identifying what these things are, and then going from there, we can get into how to register and use them. Let's get into what these pieces of intellectual property are and their differences. We'll start with the question, what's a trademark? A trademark is used to show who's providing a product or service. Think about seeing a company's logo on a product or maybe even on a SaaS website. Since IP is a right, each type of IP is fundamentally designed to stop others from doing something. Trademarks exist to stop others from selling a product or service under a brand that's confusingly similar to yours. Trademarks can protect various parts of a brand, including names, logos, emblems, symbols, colors, sounds, or designs. Trademarks can even be used to protect the look of a building. Think about why all those chain restaurants look similar. There's a reason. And yes, there are cases where companies have fought and won over their buildings appearing too similar. So why and how do you register a trademark? Trademarks come into being by using the trademark to market or sell the products or services. We call this using the mark in commerce. Trademarks can be registered to provide significant advantages in enforcing your trademark rights. They can be registered at the state level or, more commonly, federally with the Federal United States Patent and Trademark Office. One way to tell if a trademark is registered federally is that the little circle with the R is used. Trademarks that aren't federally registered can't use this symbol. It's actually a crime if you do. Trademarks not federally registered are identified usually by an uppercase TM. So what's the best way to use a trademark? The best way to use a trademark is to pick a name, a logo, and other brand elements that work well for what you're marketing or selling. And remember the importance of consistency. Once you've decided on a trademark, whether it's your company name or product name, it's best to continue using that mark. Say it loud and proud for the product or service it's paired with. As long as they're used, trademarks can actually last forever. So what's a copyright? A copyright is used to protect a creative work, like a book, a blog post, or a video, like this one, by controlling whether and how it can be copied, distributed, modified, and more. Copyrights can protect software code, promotional materials, lyrics, music, sculptures, artwork, books, articles, and more. The critical questions are whether the work is original, authored by a human. It's still uncertain whether AI can author a copyright, although some recent cases have come out saying that AI can assist authorship of a copyright. The work has to be fixed in something called a tangible means of expression, which is legal gobbledygook. An example that I find helps is that the painting is not copyrighted when the idea is in the artist's mind, but it becomes copyrighted when she paints it on the canvas. Or the app's code or design becomes copyrighted when the developer actually types the code rather than when the idea is just in the developer's head. So why and how do you register a copyright? A copyright actually automatically exists as soon as a work that qualifies for one meets the conditions that we just talked about. But they're often registered with the Copyright Office to firm up the claim to the copyright. So what's the best way to use a copyright? Well, since copyrights are automatically created when a qualified work is created, businesses often have or have access to far more copyrighted material than they realize. So given that, copyright enforcement often comes down to strategically selecting which works are of importance to the business, like designs, websites, finished videos, books, and other materials that serve a purpose aligned with the business's goals. These major pieces can then be registered with the US Copyright Office or at a minimum tracked to provide additional enforcement advantages to the business. So remember to keep in mind though, who owns the copyrights you use? A critical aspect for businesses to keep in mind with copyrights especially, but with all IP, is to make sure the business owns the copyright. So a copyright initially vests in the author of the work. While there's mechanisms in the law for an automatic transfer to the business under the work made for hire scenario, it's best not to rely on it. I typically advise it's best to make it explicit in the agreements with employees or contractors who will own the copyrights. So we get down to the question, trademark versus copyright. Why would I choose a trademark or a copyright? So one of the biggest differences between a copyright and a trademark is what triggers their existence. A copyright comes into being the moment a creative work is physically written, drawn, typed, filmed, or otherwise created. A trademark, on the other hand, comes into existence when a brand is used to market or sell a particular product or service. Though I frequently work with clients to start registration of their trademarks before marketing or selling actually happens to get ahead of the process. If something only qualifies for either trademark or copyright protection, the answer is pretty straightforward. If something could qualify for both, like a logo on a sold product, since trademarks and copyrights arise automatically, it often does qualify for both. But it's often more practical for a business to prioritize a trademark aspect or a copyright aspect of a thing over the other. Thus, oftentimes businesses will categorize their brand elements into the trademark bucket and everything else that qualifies as a copyright into the copyright bucket within their intellectual property portfolio. So why would I choose a patent over a copyright or a trademark? The other type of intellectual property protection you can apply to the government for is a patent. I often receive questions regarding how to choose one over the other, so let's just get into that quickly. So trademark versus a patent. We'll take the question of trademark versus patent first because it's easier. As an intellectual property attorney, I can't actually imagine a scenario where you'd choose a patent over a trademark or a trademark over a patent, as what they protect is fundamentally incompatible. The other one is the question of a copyright versus a patent. This one may seem a little trickier as there's some overlap as to what can be protected with a patent and what can be protected with a copyright. But it comes down to what aspect of the work that you are looking to protect. Are you looking to protect the actual creative work aspect of the thing itself, like the lines of code and software? Or are you looking to protect the idea or functionality of the thing, like what the software does? If it's the former, you may be able to get by with a simple copyright. If it's the latter, though, you'll want to consider a patent, claiming the inventive concept. If you want to learn more about intellectual property, make sure to check out the channel, make sure to subscribe and hit that notification bell for this video, and I'm happy to share more with you as time goes on to teach you how to use intellectual property for your startup to win.